So now, this was that. So I now sounded the very last bell of this year's Bergen Exchanges, and it's a good thing that it was the last, because I'm feeling that the authority of the bell is that I've heard of something called the bell curve. Is this it? Not quite. The bell curve. The authority of the bell is declining. But we do have a very, very exciting last panel that concerns us all. And those of you who know Kiki Kleven knows that this is not Kiki Kleven. So I'm going to start by introducing the member of the panel who you just heard speak, but was not, well, first I'll say a little bit about panel. So this was Esmeralda's idea some years back, and we've discussed it before, but to study the communities, the epistemic communities, and their role in specifically climate litigation this time, but in climate policy more generally. So these epistemic communities of experts in different fields and how they work together in relation to these issues. So we'll start this last roundtable by having Esmeralda Colombo, who I'm not going to introduce you anymore because you were just on, and who will introduce sort of the topic more generally. And then we have online, we have Jan Rubio de Pont, who's at Utrecht University in the Netherlands, but who is also connected to CET, the Center of Climate and Energy Transformation, that Ova just is from and directing. And he's a natural scientist, and he's been working as an expert in climate litigation. So we'll talk about that. And then Rasmus Berg, who is a climate activist. He's also a student and many other things, but he's a climate activist, and he has been involved from Friends of the Earth, the youth organization, working with climate litigation, working on bringing cases, and been involved in several cases. And he has also been observing cases at the European Court of Human Rights on climate. So he's sort of also part of this, but from a different angle. And then Catalina Vallejo, who you just met, and who's from the EFIT, is that how you say it? Yeah. EFIT University in Colombia, in Medellin, and who used to be at the University of Bergen, and who has a doctorate in looking at climate litigation, studying climate litigation. Will look at this from a more analytical perspective. But take it away.
Thank you so much, Siri. So just to give a little bit of a background, I think my fascination with epistemic communities started when I first read Peter Haas' work on epistemic communities back in the 80s. Well, I read it just for my doctoral studies 5 years ago, but it was fascinating because it was something completely new. According to Haas, a political scientist, epistemic communities were at work and no one had seen them. So what are these epistemic communities? Usually a transnational network that has moral legitimacy and authority, and is able to contribute to causal ideas about causes and effects, and can see those ideas institutionalized, usually in policies and laws that are shaped according to that evidential base. And to me, this was incredibly powerful, also because he used this adjective, epistemic, that reminded me of my ancient Greek studies and philosophy studies. So episteme is really the truth, right? It's not doxa, it's not opinion. So why do we believe that natural scientists are saying the truth? And why has seen the impacts of this now in the 80s, late 80s, when the IPCC was coming about, the first real discussions, like institutional discussions about climate change were happening. So to me, it made a lot of sense. But Peter Haas was limiting the discourse of these epistemic knowledge power to, more to natural scientists than other types of scientists. So still, this is knowledge, actually. It's not the truth, but to him, natural scientists had more of a grip into methods, just because natural sciences are more exact, the same biases that we hear about still. So there were some concessions to the importance of impact on knowledge by social scientists like us, but still no understanding of how those experts would really impact policies. So when we started talking about this 1 year ago, we realized that we were in epistemic networks. We were contributing to litigation from a lawyer perspective, a natural scientist perspective, from a researcher perspective on lawfare and climate mobilization, social mobilization. So we started thinking about creating a new definition of epistemic communities. So this is quite bold, but I would, just to give you an example of how epistemic communities can be at work. So the idea of how scientists came about for the decision given by the European Court of Human Rights, Clima Signorin. And this was an incredibly important decision back from this spring. And the use of science is unprecedented compared to other decisions. It's the first one on climate. So we can see that this is probably the pedigree of further decisions. And just to understand how this is political and how social scientists are really called to think about this role of knowledge, is that the decision found that Switzerland had not done enough in terms of climate mitigation policies. And the parliament in Switzerland in June ruled that they would not comply with the decision. So just taking it from here, I think that scientists like Jan can really say a lot about how we are communicating about our knowledge, how we can still be legitimate in this transnational network of scientists. Thank you.
Thank you, Esmeralda. Wonderful. And that's so now we're lobbing the ball to you, Jan, because tell us about how you've been involved and how you see this.
Thanks a lot. So how I've been involved in epistemic communities, I'm actually discovering as I hear more and more about it from Esmeralda. So I'm also discovering this approach, and it's very interesting to see as a subject of to see that what we're doing is also a subject of study. So getting back to the contributions that I've made. So as a scientist, I work on trying to quantify what is fair for each country to do. And because I was working on this, I've been approached by jurists and lawyers to inform the courts in several court cases around the world, including the first successful court case, I think, against a country, which was the Urgenda against the Netherlands. And since then, I've worked on several others, including 2 recent cases before the European Courts of Human Rights, one that was not successful, Duarte Agostino, and one that was successful, the Clima Signorin case. And otherwise, I've also informed court cases against oil company, the French oil company Total Energy, and recently one against Norway regarding the authorization to drill certain sites. So the role as a scientist in there, I find is very linked to that of jurists, and I think more than we realize. And I think this is very relevant to the definition that Esmeralda brought of the epistemic community, because there is really something about having norms and institution. The global warming as an issue is initially a physical issue with threats to tons of ecosystems. So it is a scientifically established danger. But the reaction to this was to have a legal agreement such as the Paris Agreement, which was also informed by a lot of scientific papers, to define certain norms as to what we would want to do as a world, and then also certain norms in terms of fairness as to how much each country should be doing. So then this legal document, which was an interpretation of physical threat, was turned again into policies at the national level. And then again, there was the question of asking scientists whether or not the policies were consistent with the global Paris Agreement, but using science. So there's really a back and forth between scientists and jurists. And so there's been that work done to do local policies, but also court cases to check whether or not each actor, each country in this case, was doing its role, was playing its role. And so across country, the way to assess whether a country is doing enough or not is fairness. So that's the measure for ambition. So the court is not trying to do what's fair, but it's trying to apply the global agreement. And it happens that the only way to characterize whether a country is in breach is to look at what's fair. So we try to provide quantifications as scientists, as Esmeralda mentioned. We look at consequences and implications of choices, and we explain, okay, if a country emits this much, then it can be considered as a breach of this principle or that principle. But the question as to which principle is to be applied is ultimately a normative choice for decision makers, for courts as well to interpret. So the role of scientists here is to present the evidence. And then there's a question for the court as to what is evidence or what can be used as a proof. And here, I think in the climate space, of course, scientists are probably not listened to or understood enough, but this is probably one of the area where the science has an important effect. And the IPCC or legal bodies of the different countries really play a role in convincing the court. And I think courts and judges have made great efforts into going into the science and trying to understand how to use it. So maybe I'll conclude with just saying very quickly what the Klimassenioringen case has done. So the Klimassenioringen case, which was the victory of an association of elderly women in Switzerland suing the states of Switzerland, has basically applied, the court has confirmed that the Paris Agreement does apply, including in light of human rights, to countries. And so that means that countries have to explain how they're doing their share of the Paris Agreement. How are they doing their share of efforts to limit global warming to 1.5 degrees, and that it can be checked against science. And in this case, the scientific evidence that we presented, we as a community, showed that Switzerland was not doing enough. So the court did not decide for a formula to apply to each country, but it said that Switzerland had to demonstrate how it's doing enough. And at the moment, even with the net zero pledge for 2050, that, by the way, Norway doesn't have, even with that, that was not sufficient to show the total amount of emissions that Switzerland would emit and how that's acceptable as a contribution to global warming globally. So I'll just finish by saying that this court ruling was against Switzerland, but it applies to all the members of the European Courts of Human Rights, which include all members of the European Union, but also Norway, Iceland, and a few other countries.
Wow. So extremely interesting. Thank you so much, Jan. So I want to just ask you, Rasmus, because you have been in Natur och Ungdom, and you're the youth environmental organization. You've been, you as an organization, you've been involved in many court cases, and you have been part of sort of a group that has been involved in a lot of this work. So I just wanted you to reflect on this type of collaboration from an activist point of view.
I think I can just continue on what you've said already as well, that of course climate litigation wouldn't really be a thing without scientists and all the tremendous amount of research that has been done on climate. In both our cases, we make heavy use of the IPCC reports. We use simulations of how oil spills can happen to kind of prove how nature will be affected. And a lot of what's happening in court is just laying out the science and what is happening. I think kind of the reason why we're seeing so many environmental organizations going to the courts, especially on climate issues, is because our politics has been disconnected from natural sciences, especially, and of course are kind of helping us connect them back together, and like kind of making a framework to that the policies can be shaped within. The first case, just want to say a bit about the Norwegian cases.
Yeah.
The first case was lost. We tried to invalidate several exploration licenses in the Arctic oceans, but we had two major victories. The first one was the fact that although for the exploration step of the process, the court wouldn't intervene. They said that at the last step, when companies apply for a plan for development and operations, at that point, the state has both a right and a duty to reject the application based on climate when the sciences say so. So that's quite important. And if you look at science today, we have reached that point today as well. So that is probably something that is the case for the last several years, especially after the Supreme Court verdict. The other thing that was that when applying, the environmental impact assessment has to include an assessment of climate damages. And this is also something that is happening several other places. I believe that in May, this was also included in the International Tribunal on the Law of the Sea. The UK Supreme Court also ruled in kind of the same way in June. So this is happening many places. And it's also led to a new field of study called attribution sciences, which is how can we prove climate damages, or how can we attribute climate damages to specific projects and specific policies, which is now a lot of what we do in court as well, bringing both criminological perspectives, natural sciences, and social sciences as well.
Wonderful. Excellent. Esmeralda,
Yes.
I'm actually going to ask you, Catalina, first, because I was thinking back when Rasmus was talking about saying that we use court as a space because then it's easier to bring the science. I was reminded that this is more than a decade ago, it's actually more than a decade since we started working on this together. And one of the first, and you were looking at all the US cases, and one of the things that we really saw early was that the sort of science was brought to bear in a very different, in many of these cases, in a very coherent manner. So I just wanted to, but you can say whatever you want, but I did just brought this back, that this is there's something about the forum, and it's connected with this, that it is something about these epistemic communities that sort of converge on the courts, because there is, it's something about that arena that is different from some other arenas.
Yes, it is. So I remember that we were surprised when we started mapping climate litigation in different countries in the world, because of course, when you think about the political branches of power, the executive, national governments, sometimes even parliaments, there was a lot of climate denialism, no? Like this idea that, people who were campaigning for presidents, and very especially Trump in the US, and we started cases even earlier than that. It was easier, 2010, 11. So it was easy, it's still easy for some governments to say climate change is a hoax, it doesn't really exist, there is natural climate variability, this is not really caused by humans. But what happened, and people vote for different parties, and in parliament they don't pass legislation because they weren't so sure. Now we are kind of very sure. Now it's a different time, we have different types of conversations. But before parliaments were like, we're not really sure the planet is warming, and we're not really sure about the effects. And this is going to be in the future anyway, so in the very far future. So this is too abstract, this is too far away. It's impossible to think of rights discourses or even like material compensation or monetary compensation for people, because we're not sure what's the cause of this. And if the cause is greenhouse gas emissions, it started with the Industrial Revolution, and everyone is contributing to this. So it is impossible to connect a cause or an individual or even an industry with the effects. So legally, there's nothing to do. But then we started seeing in US cases, in Australian cases, and now everywhere in the world, that when people were bringing climate cases to courts, the judges have a different way of deciding. So they have to analyze evidence, proofs, reasoning. They need to write down their decisions, and they have to, it's impossible just to give an opinion, right? They have to argue their decisions. And so if you have something like the Intergovernmental Panel on Climate Change, which is scientific consensus on like meta-analysis on climate science, it's impossible for a single judge who is not an expert to say this isn't true, or this is false, or this is a hoax, or this doesn't exist, or we are not sure, right? If the scientific consensus was saying, which is also based on the UN, approved by states also, was saying there is a very high probability of this being a phenomenon and of it having a human cause, then what can judges do? They can only say, okay, this is what it is. And they cannot call just like one expert to the courtroom to argue against scientific consensus. So it started to be solid evidence or proof in the court cases. And then it was impossible just to say, we're not sure this is a real phenomenon. And so the judges had to take in the cases and start analyzing harms and possibilities of liability and compensation. I have some other things to say, but maybe later.
No,
Just wanted to.
Because I know there are
Okay, just thinking about the epistemic communities and the word expert. No, Siri posed a question before, like, okay, who are the experts and what is expertise about climate change? So the very easy looking up in the dictionary. So expert, the Oxford Dictionary says, a person who is very knowledgeable about or skillful in a particular area. For example, an expert in healthcare, a financial expert. And then adjective, having or involving a great deal of knowledge or skill in a particular area. So knowledge has been central to climate litigation, thanks to the connection with the epistemic community, that is the scientists, climate scientists, and scientists in different areas, including the social sciences. And so it was important for climate denialism and to start really taking seriously the issue of climate change and human rights. And then and thinking about liability, state liability and corporations liability. And what I want to bring to the table, to this discussion, is we've been having experts talking about the causes of climate change and possibilities for climate mitigation, also who bears responsibility for mitigation. And also like we have science about the carbon majors who have been contributing the most, and so who should cut the most or compensate in case of hurricanes or other disasters. But I want to talk about climate adaptation and what it means to be an expert on this. And this opens up the discussion about epistemic communities as well. So I just want to talk about some examples from the city where I am from and where I live, Medellin, which is a highly unequal city. And in this city, we have some neighborhoods that have been built in the mountains due to the dynamics of the armed conflict in Colombia. Displacement of people from different places, especially rural areas, have come to bigger cities to find job opportunities, to have a different life. So we have neighborhoods that are like informal, we call them informal neighborhoods. And the situation there is like they are not really in the territorial ordering planned by the municipalities, because they kind of didn't really exist, were not planned to be there, but they are just there now. And they are very vulnerable to the effects of climate change, to flooding, in general, they're very vulnerable to risks and environmental risks, social risks of all kinds. And there is a very interesting experience in a place called Comuna Ocho. And so the citizens created something that they called Panel Interbarrial de Cambio Climático, which roughly translated means inter-neighborhood panel on climate change. And what they say is the authorities, we basically don't exist for the authorities, and nobody really understands the risks of our neighborhood, because we are too vulnerable to many different things. And they even have like migrants from Venezuela now. So there is a whole bunch of different situations going on, and they are claiming agency to be the experts on their adaptation to climate change, or what they need and what kind of support they need also from the state. So just want to bring that to the discussion.
Absolutely. And what expertise counts, who are, which types of knowledge should be included on a relevant these days, of course, extremely. This also brings us to from the former panel, and also from the discussion we had on these issues last year. So I wanted to bring it, before opening up, I wanted to bring it back to you, because you just sort of set the stage. So now I want you to.
Right. So just expounding very briefly on some of the points raised by Jan, Catalina, Siri, and Rasmus. So I think that we can sum up a little bit the discussion by saying we can all take epistemic responsibility. Probably that's more of an inclusive term. So understanding our power in knowledge. So epistemic responsibility is something that a lawyer, Liz Fisher in Oxford, at Oxford, evolved quite nicely. So her way of putting it is, our responsibility concerns whom we talk to, whom we listen to. So some of the indigenous peoples we talked to last year from Argentina told us, well, epistemic communities are colonial. To us, the knowledge that has been superimposed is really not co-developed. You know, it's not something that we could have a say on. And sometimes the focuses are scotomization. You know, you focus on something and you forget about the rest, the sides. And we are in the sides, so you forget about people. So if we humanize a little bit this narrative about epistemic communities and open it up to more disciplines, not just the natural science disciplines, then I think we would better include also people to understand very complex matters. We talked about energy, we talked about inclusion through participatory rights. So if we can simplify it, as lawyers, that's a big challenge as well, but we would then include much better and feel responsibility when the time comes, you know, to say, okay, now we listen really attentively and then implement in new laws, new ways of creating value for communities. So now I think we can open it up to the floor if some other epistemic minds are at work.
Yes. So I think Kim, you can start. We'll send you that.
Wonderful. Thank you so much. And actually, I was going to be optimistic, because this is an area where courts all over the place are making really major decisions. And one of the ones that would be really worth, I think, looking at in the context of this discussion is one that was from March 2021 of the German Federal Constitutional Court, right? That was the one where they actually had to, I mean, it was decided on the basis of intergenerational justice, you know, that the climate change targets the German government had set were not high enough to prevent a catastrophic effect for the generation that was bringing the case, which is kind of the opposite in some ways of the Swiss case, because in the context of the Swiss case, the only damage that the court recognized was the current existing damage to older people from heat waves, which is to say there was nothing in the future about that case. It really was quite limited in the harms it represented. The German one, though, was like just, I mean, I would urge you all to read it if you're interested in this. It's in English, it's on their website, March 2021 climate change case. And it's just remarkable in terms of its kind of intergenerational justice vision.
So again, two things. The first being, when we have the Uganda case, for example, that directly sort of goes to the Netherlands. But I'm sort of concerned about the inequality between countries because the polluting happens elsewhere. And we know that the limitation of domicile laws, then there's no redress at the source. So at that point, and I'm looking at paper, looking at these legal challenges and opportunities, looking at the future, and trying to see how do we bridge that. Because secondly, would then touch also Norway with Equinor that has a state-sanctioned right to pollute. And so it's how do we then bridge that as well? And lastly, it's enforceability. Norway is blatantly ignoring a court judgment, and many countries are doing the same. So in the previous panel, we talked about just going beyond. And if we're thinking about setting a research agenda, it's to say, how do we go beyond?
Okay. See if I make any sense at this point in the proceedings, but I'm glad you complicated the notion of episteme and epistemic communities. If we think about epistemes as truth regimes, rather than transnational networks of actors that influence policy outcomes. And listening to you all talk about the interactions of law and science, made me kind of think again about Sally Merry's book on the seductions of quantification, where she talks about measurement systems as forms of power that incorporate certain theories of social change that are not often acknowledged as such. So it kind of leads me to think about what we think about law in this story. I mean, there may be other places that people are taking, their truth regimes to face up to, the consequences of all of this. So that was kind of one. It's not a coherent question, but I just want to kind of challenge you all a bit on that. And then the second is like authoritarianism, green lash, I mean, listening to you all, and we all read the IPCC, and, but like, this is not established truth regime. It may be for the scientific global consensus, but I mean, certainly, how is this going to play out in terms of how's the backlash playing out in terms of what you're seeing for climate litigation? Yeah.
Very interesting and important questions. Anna?
Thank you. Yes, my question was a little bit inspired by this paper written by our fellow here, Eva Fjellheim, who isn't here, on the Fossen case. And she wrote a paper about the epistemic clashes, actually, in the Fossen case. And kind of what I want to ask you, perhaps Jan and Rasmus, well, to everyone, is what are the odds of having, again, like epistemic communities with certain interests and orientations, and that finally you have two epistemic communities arguing different results with different things about a certain phenomena, and that at the end it will be also responding to, I don't know, the autocratization of scientific communities or whatever. So yeah, what are your take on that? What is your take?
Thank you, Anna. Very, very important question. Do I have any? If you don't put your hand really high, I'll go back to the, no, so I will go back to you. That's great. So there are lots of very good and very difficult questions. And I think I'm going to go to Jan first, because it's difficult to be online, because it's so easy to forget. So please, you can start out.
Thanks a lot. I'll start with the question on Klima Seniorinnen and Germany. I was very slightly involved in the German case. Of course, it's quite different. And also, I want to remind that there was the Duarte Agostinho case, which was on behalf of Portuguese children that were threatened by climate, global warming and forest fires. In this case, it was not admissible, not really for issues of recognizing the science and so on, but because it tackled directly the European Courts of Human Rights without exhausting the remedies in Portugal. But both these cases were reviewed at the same time by the European Courts of Human Rights. So there's strong reasons to believe that the evidence that were presented in the other cases, so Duarte and there was another one, also informed the courts as to how the science works, what is at stake, both for the youth and the elderly. And so there is the qualification of the victim status. But beyond this, I think the court had a lot of material to understand the threats. And so I hope that this is taking part in a broad understanding. And I think from a scientific perspective, the fact that a court tries to really impose that 1.5 degree is really the threshold for global warming is very important for future generation. It is not the only way to look at warming threshold, but using using carbon budgets is also a way to manage intergenerational justice. So I think there are lots of tools that allow to do both at the same time. On what was mentioned also on international justice, I think this is very intrinsically linked. We have sort of a discount rate for care, and this is very well also used by economists to give less value to what's in the future and less value to what's distant from us. And we can think distant socially, distant geographically, etc. And so the questions of justice, of course, are very interlinked. So I wouldn't necessarily oppose the results of the two court cases. And I think they go in the same direction. What is also very interesting when using carbon budgets, also as I think the decision in the German cases also raised that point, is that the budget, the global carbon budget from 1.5 degrees is nearly extinguished already. And it depends on how likely we want to be to achieve, to stay below that threshold. But it's really shrinking very quickly, and soon we will have even less than a 50% chance to stay within that budget. And that asks the question, what does a court do then? Can it impose to shut down the economy entirely? And that was raised during the German case, and this is an important point. And then what does the court do if shutting down the economy infringes other human rights? And so there are important questions here on the value of intergenerational justice, but also counting for the justice of current generations and the efforts to be done. Moving on to another question on the truth of numbers. I think this is very important. As a quantitative scientist, I try to provide better numbers than no numbers. And sadly, it tends to be that when something is not quantified, it is often taken to zero value, including nature capital in general, so to say. But of course, non-quantitative approaches would be hugely beneficial. And I think it's a failure that these have so little weight. And I think in legal terms, it's a bit the question of trying to achieve goals versus trying to rule by principles, including precautionary principle. And the Paris Agreement has goals, of course, but it also has the requirement to do highest possible ambition. And that is not just limited to 1.5 degrees. And on maybe the last point on conflicting epistemic community, yeah, we find this all over the place in science, in law, in epistemic community, transdisciplinary. Some it can be very constructive, and this is also how we progress. At least that's how I feel. I've been opposed by a lot of scientists myself that helped me realize some of the weaknesses in what I was doing, or how a message can help some stream of, say, lawmaking and may not be understood the same way in applying the law or in court cases. And so it's very interesting to have those different epistemic communities, and that, yeah, even through constructive conflict, they can feed each other. But I understand that, yeah, in some cases, they can be unresolvable questions. Yeah, I'll stop here. Thank you.
So thank you so much. Thank you so much. A lot of insights on many issues. I wanted to actually ask you, Rasmus, about this because this competing epistemic communities, because you were also part of the Fusen case, and where there was this alliance between indigenous youth organizations and the organization that you were working with. So and I think it is an interesting. So there are many, and in Norway that was sort of, to many, very surprising that you had this alliance, because the case was about windmills. We heard about it earlier today. So in a way, the argument of the government was that this is necessary for the green transition, which would then be something that the environmental youth would generally be fighting for. And then you had this alliance against the windmills, which was in many ways surprising. But then, of course, you have other truths in this. So could you say something about this? Is this something that you were thinking about?
Yeah, of course. I think you have to have a different conversation about climate and environment here, because for environmental issues, you will more often than not have these conflicts. In climate, it's not epistemic community versus epistemic community. It's usually science versus bureaucracy and political processes and diplomacy, and kind of states trying to get away from the science. In the Fosen case, as hopefully in every other kind of similar case will be, this was kind of solved by really the word climate justice, because you can't have climate justice without human rights. That has been a slogan for the environmental movement for a long time. And we are human rights activists, not just climate activists, all of us, I'd say. So it is just this understanding of we're trying to protect the environment. The people who has been protecting the environment forever is mostly indigenous peoples, and we have to work together to solve that problem. But in climate litigation, it's a completely different world. It's usually governments arguing that the laws say, hey, this is not our responsibility, or we're doing everything we can, and it's just sharing the burden with other countries. If I can say something about international justice in the context of climate litigation as well, of course, we do risk governments in the global south being held responsible for the actions of mainly international companies, usually Western companies. And in doing so, governments may be limited in how they can care for their citizens and what they can provide, which is quite scary. I think the way we solve this is to disconnect the legal responsibility of states from the political sharing of burdens that we have through the Paris Agreement. Usually in court, the government will say, hey, we have a system of cutting emissions that all countries has agreed to, that is the Paris Agreement. Therefore, we are doing what we are supposed to. There's not a legal responsibility to do anything else. But that can be defeated through human rights-based arguments and national legislation in probably quite rare cases, saying that the human rights-based responsibility is much, much larger than just domestic emissions. Especially Western countries have a duty to reduce also the emissions that they control outside of their borders. This was, I think, successfully argued in the Klimaunionen case, that the court accepted this reasoning of embedded emissions, that Switzerland also has to cut the emissions from goods they import, which can hopefully, and we argue that in our cases, be expanded to the emissions we export as a fossil fuel producing country.
Thank you.
So yeah, one of the takeaways that I had, it was more of a funny thought. There can be so many conflicts, and at least we use our intelligence for those conflicts, right? I would never see any substitution of judges or experts in climate cases with artificial intelligence, for example, right? So this idea of using our intelligence, our human intelligence, and being able also to embrace contests, because there is always going to be a lot of community struggles also based on the kind of knowledge we want to, bring to the floor. So with this, funny thought, there's not going to be any AI here. It's not like any kind of criminal judgment where AI has been used so much, understanding can the person go on parole or not. At least the complexity of climate change can preserve our intelligence and the possibility to be able to use it. So in that sense, I was reminded of the idea of epistemic rights and epistemic justice. So a researcher wrote recently about AI law and the fact that to him there is this rise of a fourth wave of human rights. So the first one we all know about, civil and political rights back from the 1800s, and then economic, social, and cultural rights, including environmental rights last century. And then, more of a community movement of rights, so the right to peace, right to, ecological protection as the third wave of human rights. And since you were talking about human rights and climate change, so the fourth wave of human rights, according to Steve Rees, was epistemic rights. So the possibility to use our human intelligence instead of being, being lopsided, being sidelined by something more AI driven that is more impersonal. So I think one of the takeaways of the epistemic struggles that we're seeing is really the fact that by reading, by learning, by being, with people, sharing knowledge, we can actually use our intelligence to make the small improvements that we need. So in this way, epistemic rights is something that unites us. So this is, just more of an understanding of how much we need these kind of judges in epistemic networks, judges that want to learn more. So also by making us more understandable as researchers, as people, I think we can actually do them service because the climate is so complex, and justice is probably even more complex because it's about really how we put knowledge at work.
Thank you. I want to, before I give the word to you, I think one of the questions that have been coming out is this about when you have, I mean, these are really, really contested issues, right? So one way in which we try, and they're in a way too contested to make, and there are too strong interests involved to make project careers politically in many cases, right? So we move them into the courts. And I think one of the questions that was there is that, what about the backlash that then comes? I mean, we've been talking about sexual and reproductive rights. We've seen some of the same issues. You bring in the science, you create these epistemic communities. And then you get, the sort of shadow, or you get the mirror community, which then sort of comes in, and then what happens to the courts? Can they take the burden? What happens when you have these cases? And I think this is also one of the questions that I want to. So of course we have now 7 minutes, but I wanted to put them to you, Catalina, because you've been thinking a lot about that. What are the strategies? Because I think that there are different paths that judges take. So you have some really, really big judgments. they have some like landmark judgments that we all know, even if we don't work closely in the field. But then you have also other strategies that judges use that I know that you've written about. So I'd love that ball to you.
Thank you, Siri. Yeah, so we've been discussing this for years, that when judges have to decide on structural cases, it's risky business for them, no? They have to, in the Colombian Constitutional Court, of course, is a long used example of judges intervening in the economy, in health policy, in different kinds of, policies, public policies. And now when we think about judges around the world deciding climate cases, it's like they need to save the world in a ruling. And this, it's not very popular. It's difficult. They have to go against the industry. They have to go against public policies. And what we have found out is sometimes judges don't want to do these things. They are also worried about their personal life. They don't want to be in the public light. They not necessarily want to take all these risks. And connecting to what Wesley asked before about how to go beyond, and how about implementation? This is also something I've been thinking about a lot about lately, not only when it comes to climate rulings or cases, but also rights of nature cases, as I mentioned before, like rivers with rights, different types of environmental law cases and rulings and decisions, how to implement them. We don't see them implemented, or just like we discussed with Marta before, using like special criminal law or armed forces. And I think also back to what Esme just said about using our intelligence, I think we really have a challenge to harmonize a lot of different things, like different aspects or rights or interests that come to in climate litigation, like labor rights, socioeconomic rights, and environmental protection. The trade unions, as we mentioned before, are one of the biggest sources of backlash of against climate litigation, because it's the miners, who are the biggest unions, the carbon industry, the miners. So we need to harmonize. Judges really need to start using environmental principles, constitutional principles, to harmonize different aspects and interests. And some of them have been doing it, but still a lot of improvement to do. And also harmonizing the branches of power, So also a lot of the Bergen Exchange is about judicialization and the role of courts in social transformation, and the impotence when I'm in front of all these rulings at Trato River, at the Amazon, and the litigation and climate. It's yes, the courts are doing it. Some judges take the risk, but then the executive branch is not doing anything. It's just putting the drawer, and then the parliaments are not developing the laws to make this permeate administrative law, labor law, civil law, commercial law, trade. It's not happening. So I don't know. I'm very happy to see Marta working now for a government. And I think maybe for the agenda also for the next decade, we need to start focusing also a lot on the political branches of power and how to push them, and the role of civil society in that.
I think this is an amazing place to stop. And I think that we've talked about administrative law a lot. And I think we need to look there as well. I think this has been an amazing discussion. And I think it's sort of also like many of the discussion, it means that we need to meet again next year. So unless there has been a very successful case against Norway, getting all the money from the oil fund, which of course wouldn't be unfair, but I would like there to be a little bit left for the very next year. Next year as well. So thank you. Thank you so much. And somebody will have to turn your thoughts. Just say.
Can we get the Bergen Exchanges panel up there? I know that. I want to chat to you.
I will get everybody. So, can somebody help me get lots of thoughts? because that's exactly what we're doing now, because this is the official closing. And those of you, can somebody throw me the ball? Where is the ball? The box. The box. The box. Yes, I want the box. The talk box. And you're very strong. So you can. I'm extremely bad at it. I told you, but it didn't work. Okay, but I want to keep it because I'm going to move around a bit. So you all know what this means. First, Jan, you will get your cup when you come back to Bergen. This is for you. You'll get it when you get back. There you go.
Thank you.
You have it. You are. Yeah. And